So the man's life was just completely absorbed in the United States Capitol in one way or another over time, and it would have been quite remarkable to actually see him in action.
Just a quick look at the old Senate chamber, and that comes from our series, The Capitol, of a couple of years back. You can find that on our website. Go to cspan.org. All the way down at the bottom, it's in past series. The reason we're showing that to you, of course, is senators will meet in a joint caucus this afternoon behind closed doors in the old Senate chamber at 6 p.m. Eastern. The meeting being held to discuss how to proceed with 7 of President Obama's cabinet and other positions blocked by Republican senators. Just a reminder, too, if you'd like to stay on top of comments about the proposed filibuster rule changes, a couple of ways for you to participate. Facebook.com/cspan. Also, if you are on Twitter, the hashtag we're using this afternoon, this evening, is C-SPAN Chat. Senate's gaveling in next. We'll hear some general speeches and likely hear from the Majority Leader and Minority Leader right out of the chute. Live coverage of the Senate here on C-SPAN 2.
Senate will come to order. The chaplain, Dr. Barry Black, will lead the Senate in prayer.
Let us pray. Shepherd of love, sustainer of our lives, and superintendent of our destinies, we honor your name. Lord, in these turbulent times, we continue to look to you, our helper, as you lead us beside still waters, restoring our souls. Help us to trust you even when we don't understand your providential movements, as we find joy in your presence each day. Thank you for your constant love and for your reminder that in everything you are working for the good of those who love you and are called according to your purposes. Guide our senators, keeping them from deviating from strict integrity as they strive to live worthy of your love. We pray in your sovereign name. Amen.
Please join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Clerk will read a communication. The clerk will read a communication to the Senate.
Washington, D.C., July 15, 2013. To the Senate, under provisions of Rule 1, Paragraph 3 of the Standing Rules of the Senate, I hereby appoint the Honorable Tim Kaine, a senator from the Commonwealth of Virginia, to perform the duties of the chair. Signed, Patrick J. Leahy, President pro tempore.
Mr. President,
Majority Leader.
I now move to proceed to calendar number 124.
The clerk will report the matter.
Motion to proceed to calendar number 124, a bill to amend the Higher Education Act of 1965 to extend the current reduced interest rate for undergraduate federal direct Stafford loans for 1 year and so forth.
Mr. President,
Majority Leader.
following my remarks, time till 5:30 will be equally divided and controlled. At 5:30 there will be a roll call vote. There will be a live quorum requested, and Senator should be advised that that may not be the only vote. We may have to have some more votes before we start our joint caucus, which is scheduled for 6 o'clock. I hope there will only be need for one vote, but we should know 5:30 or thereabouts, but we could have several votes. I look forward to the joint caucus, Mr. President, and at this time would ask the chair to announce the business of the day.
Under the previous order, the leadership time is reserved, and under the previous order, the time until 5:30 p.m. will be equally divided and controlled between the two leaders or their designees, with senators permitted to speak for up to 10 minutes each.
And if there are quorum calls, Mr. President, during this time, I would ask that they be equally divided.
Without objection, so ordered.
Would note the absent quorum.
The clerk will call the roll.
Mr. Alexander.
Well, the Senate has gavelled into session. The Majority Leader speaking first, and we expect other speeches as well. The Senate later this afternoon, we do expect a vote around 5:30 Eastern, but not a vote, we understand, not a vote on the so-called nuclear option. Again, the Senate later today at 6 p.m. will meet in the old Senate chamber behind closed doors. That's a meeting to discuss how to proceed with 7 of President Obama's nominees, both cabinet nominees and other positions that have been blocked by Republican senators. The Associated Press writes that Senate Republicans and at least one Democrat, Carl Levin of Michigan, strongly oppose the proposed rules changes by Senator Reid. Harry Reid opened the session of the Senate this afternoon with some administrative comments and also calling for a live quorum tonight. That means that the Sergeant-at-Arms can demand that senators appear. 5:30 p.m. is when we expect those the vote or votes to happen. 6 p.m. is when the Senate will meet in the old Senate chamber. That will be behind closed doors. You can stay on top of the comments and other news about the activities this afternoon in the Senate. If you're on Twitter, the hashtag we're using this afternoon is C-SPAN Chat. We'll read some of those throughout the afternoon as well. Senators are also tweeting about today's activities, and we'll give you a look at that now.
Mr. President.
The Senator from Massachusetts.
Mr. President, I ask that the quorum be lifted.
Without objection, the quorum call will be suspended.
Thank you, Mr. President. I rise today to speak about the Consumer Financial Protection Bureau and the renomination of Rich Cordray to serve as its director. You know, several years ago, I began working on the idea for a consumer finance agency because our consumer credit system was badly broken. The laws were inconsistent, they were often arbitrary, the basic rules changed for the same kind of product, like a mortgage, depending on what kind of company sold it. People got cheated, and as we know, in 2008, reckless and dangerous mortgage lenders and Wall Street traders who made money off those mortgages nearly brought our entire economy to its knees. In 2010, Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act. The consumer protection part of that was the new consumer agency, the CFPB, which was designed as a watchdog to keep credit card issuers, mortgage lenders, and student loan marketers from cheating people. Now, there was a lot of negotiation over the structure of this new agency. Hearing after hearing, markup after markup, floor vote after floor vote. But now, the same big bank lobbyists are fighting the same fight and using the same tired old talking points about the consumer agency that they were using years ago. You know, you really have to wonder just how much money they are making fighting this fight over and over. But now, let's go ahead one more time and talk about the facts. Congress built in many features to the consumer agency so that it would have strong oversight. And let me share just a few examples of that. The CFPB is the only agency in government that is subject to a veto from other agencies over its rules, the only one. The CFPB is the only banking regulator that is subject to a statutory cap on its funding, the only one. The CFPB director is legally obligated to produce regular reports to Congress, to testify before Congress regularly, and to comply with audits. And, Mr. President, the CFPB has now testified more than 30 times before Congress, 30 times. In addition, the CFPB is subject to all the regular constraints in our system of government that constrain every agency, the Administrative Procedures Act, judicial review, and so on. And of course, there's the ultimate oversight. Congress can overrule any CFPB regulation. Now, since the agency has become law in 2010, there have been two major developments. The first is that Director Cordray has done an excellent job. He's won praise from consumer and industry groups and from Republicans and Democrats for his balanced rulemaking and his measured approach. Small institutions like community banks and credit unions, the ones that didn't cause this crisis, think he's been fair and effective. And other institutions that want a fair marketplace, those that don't want to make a profit by cheating their customers, they like Rich too. And Mr. President, The agency is working. It's already forced credit card companies to refund nearly $500 million that they tricked consumers out of. And the Complaint Center is giving tens of thousands of people a chance to fight back when they're cheated. The agency has helped out military families, seniors, students. It's helped a lot of people. The agency has become the watchdog that so many of us fought for. And Rich has surpassed even the high expectations that I had for him 2 years ago when I stood next to him in the Rose Garden as the President nominated him for the first time to the CFPB. Now, there's been a second development since 2010 as well. The need for certainty has intensified. It's been nearly 5 years since the crisis, 3 years since the passage of Dodd-Frank. The banks need to know for sure who is in charge and what rules apply. They need to know that everyone will be playing by the same rules and exactly what those rules will be. And here's an example. Both lenders and consumer groups have praised the CFPB's new mortgage rules. Now it's time for everyone to know that these rules, and not the unpopular default rules that are in Dodd-Frank, that the new rules replaced, that the new rules are the law. That helps everyone. The American people deserve a government that will hammer out good rules, that will enforce those rules, and that will get out of the way so that markets can work. They do not deserve endless relitigation of stale political disputes and the uncertainty caused by repeated filibusters of qualified and proven nominees. Now, Mr. President, I'm new to the Senate, but I don't understand why this body accepts a system where this kind of political stalemate isn't going to end in more government or less government, but just in bad government. Government that lacks consistency, lacks clarity, lacks predictability, that honest businesses and hardworking families need to plan a future. And I don't understand why we would let an honorable public servant like Rich Cordry get stuck in this nonsense. I don't understand when everyone says Rich is terrific, why we can't just vote on his appointment. You know, I know that some Republicans and some lobbyists think that Rich's appointment, if they filibuster it, that they're somehow going to be able to shut down the work of the agency. They think they can shut down the agency and protect the big banks from any meaningful consumer rules. Well, Mr. President, they can use all the slogans they want. They can talk about things like accountability. But outside the halls of this Congress and the fancy lobbying offices around Washington, no one wants more fine print and more tricks and traps. No one thinks it's okay to cheat regular people and to cut special deals for giant banks. And no one wants to take cops off the beat so that big banks can break the rules without being held accountable. So let me be clear to those who think this filibuster will shut down the work of the new agency. Let me be crystal clear. The Consumer Financial Protection Bureau is the law, and it's here to stay. Do your dirtiest in obstructing the confirmation of the new director, but the agency will keep on doing what it does best, fighting for the American people. We fought to get this consumer agency. We fought the big banks. We fought their army of lobbyists. We fought hard and we won. Now we have a strong and independent watchdog to stop the banks from cheating families. We're not giving up now. Thank you, Mr. President. I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
Senator Elizabeth Warren of Massachusetts speaking on the Senate floor about the nomination of Richard Cordray to lead the Consumer Financial Protection Bureau. He actually is leading that agency now. He was appointed by the president in a recess appointment. You may recall Senator Warren was once considered the leading candidate for that role before she became a U.S. Senator. She had served back in 2008 and 2009 as chairman of the Congressional Oversight Panel. Again, the Senate in today up till about 5:30 when we expect at least one, possibly more votes, and one will be a quorum, a live quorum calling senators to the floor. We know that. Also, the Senate meeting behind closed doors today in the old Senate chamber in the Capitol at 6 p.m. Eastern to discuss the proposed rules changes, the so-called nuclear option on the filibuster. You're watching live Senate coverage on C-SPAN 2. The U.S. Senate came into session about 20 minutes ago. This afternoon at 5:30, we expect at least a vote, possibly a couple of votes, and then at 6 p.m., the Senate will meet behind closed doors to discuss in a joint caucus, a closed caucus, the proposed rules changes regarding the filibuster. We're keeping our eye on C-SPAN chat. If you're on Twitter, that's the hashtag to use for our Senate coverage this afternoon. Tommy Yergin tweets, "I wonder if the filibuster rule will actually be changed. Hopefully, as Senator Sessions said last week, cooler heads will prevail." Also from the tweeter, Mr. Speaker, who says, for those who want to see a unicameral legislature, what a unicameral legislature is like, the grass isn't greener. Again, C-SPAN chat is the hashtag. We're also on Facebook, facebook.com/C-SPAN. Well, while this quorum call continues, we're going to at least bring you a portion of the back-and-forth discussion on the Senate floor from last Thursday between the majority and minority leaders.
President, I move to proceed to executive session to consider calendar number 51.
Is there objection? No. I'm sorry. The question is on the motion to proceed. The question is on the motion to proceed. All those in favor say aye.
Aye.
Aye. All those opposed say no. The ayes appear to have it. The ayes have it.
I send a cloture motion.
The motion is agreed to.
Thank you, Madam President. I send a cloture motion to the desk.
The clerk will report the nomination.
Nomination. Bureau of Consumer Financial Protection, Richard Cordray of Ohio to be director.
The clerk will report the closure motion.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Richard Cordray of Ohio to be director, Bureau of Consumer Financial Protection, signed by 18 senators as follows. Read.
I ask unanimous consent, Madam President, we not read the names.
Is there objection? Without objection.
I now move to proceed to legislative session.
The question is on the motion to proceed. All those in favor say aye.
Aye.
Aye. All those opposed say no. The ayes appear to have it. The ayes do have it.
I now move.
The motion is agreed to.
I'm so sorry again to interrupt you. I move to proceed to executive session to consider calendar number 100.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The clerk will report the nomination.
Nomination. National Labor Relations Board, Richard F. Griffin, Jr. of the District of Columbia to be a member.
I send a cloture motion to the desk.
The clerk will report the cloture motion.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Richard F. Griffin, Jr. of the District of Columbia to be a member of the National Labor Relations Board, signed by 17 senators as follows. Read.
Madam President, I ask unanimous consent that the reading of the names be waived.
Is there objection? Without objection.
I move to proceed to legislative session.
Question is on the motion to proceed. All those in favor say aye.
Aye.
Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to.
I move to proceed to calendar number 101.
The question is on the motion to proceed. All those in favor say aye. Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The clerk will report the nomination.
Nomination, National Labor Relations Board, Sharon Block of the District of Columbia to be a member.
I have a cloture motion, Madam President, at the desk.
The clerk will report the cloture motion.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Sharon Block of the District of Columbia to be a member of the National Labor Relations Board, signed by 17 senators as follows.
I ask unanimous consent that the reading of the names be waived.
Is there objection? Without objection.
I now move to proceed to legislative session.
Question is on the motion. All those in favor say aye. Aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it.
I now move.
The motion is agreed to.
I now move to proceed to executive session to consider calendar number 104.
Question is on the motion to proceed. All those in favor say aye.
Aye.
Aye. All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to.
There's a
The clerk
motion.
will report the nomination.
Nomination, National Labor Relations Board, Mark Gaston Pierce of New York to be a member.
I have a cloture motion. I would ask the clerk to report if the chair agrees.
The clerk will report the cloture motion.
Cloture motion. We, the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Mark Gaston Pierce of New York to be a member of the National Labor Relations Board, signed by 17 senators as follows.
I ask unanimous consent that the reading of the names be waived.
Is there objection? Without objection.
I ask consent the mandatory quorum under Rule 22 of the Senate be waived.
Is there objection? Without objection.
I now move to proceed to the legislative session.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to.
I move to proceed to executive session to consider count number 178.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The clerk will report the nomination.
Nomination, Export-Import Bank of the United States, Fred P. Hochberg, of New York, to be president.
There's a cloture motion at the desk.
The clerk will report the cloture motion.
Cloture motion, we the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Fred P. Hochberg of New York to be president of the Export-Import Bank of the United States, signed by 17 senators as follows.
I ask unanimous consent that reading the names not be necessary.
Is there objection? Without objection.
Has consent that mandatory quorum under Rule 22 be waived.
Is there objection? Without objection.
I now move to proceed to legislative session.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to.
I move to proceed to executive session to consider count number 99.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The clerk will report the nomination.
Nomination, Department of Labor, Thomas Edward Perez of Maryland, to be secretary.
I send a cloture motion to the desk.
The clerk will report the cloture motion.
Cloture motion, we the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Thomas Edward Perez of Maryland to be Secretary of Labor, signed by 17 senators as follows.
I ask consent that reading the names be waived.
Is there objection? Without objection.
I ask unanimous consent that mandatory quorum under Rule 22 be waived.
Is there objection? Without objection.
I move to proceed to legislative session.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to.
I now move to proceed to executive session to consider count number 98.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed to. The clerk will report the nomination.
Nomination, Environmental Protection Agency, Regina McCarthy of Massachusetts, to be administrator.
I send a cloture motion to the desk.
The clerk will report the cloture motion.
Cloture motion, we the undersigned senators, in accordance with the provisions of Rule 22 of the Standing Rules of the Senate, hereby move to bring to a close the debate on the nomination of Regina McCarthy of Massachusetts to be administrator of the Environmental Protection Agency, signed by 17 senators as follows. Reed, Boxer, Cardin, Coons, Leahy, Carper, Wyden, Murray, Udall of New Mexico, Heinrich, Sanders, Whitehouse, Baucus, Durbin, Gillibrand, Merkley, and Schatz.
Ask consent the mandatory quorum on Rule 22 be waived.
Is there objection? Without objection.
I move to proceed to legislative session.
The question is on the motion to proceed. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The motion is agreed.
Madam President.
Republican leader.
Madam President, I have a consent that I think would set up these votes in a much more expeditious way than the way the majority leader is proceeding. But first, let me just say, these are dark days in the history of the Senate. I hate that we have come to this point. We've witnessed the majority leader break his word to the United States Senate. And now our request for a joint meeting of all the senators has been set for Monday night, a time when attendance around here is frequently quite spotty, in an obvious effort to keep as many of his members from hearing the concerns and arguments of the other side as possible. It remains our view that for this to be the kind of joint session of the Senate that it ought to be, given the tendency of the Senate to have sparse attendance on Monday night, to have this meeting on Tuesday before it's too late. Having said that, a more expeditious way to accomplish most of what the Majority Leader is trying to accomplish would be achieved by the following consent. I ask unanimous consent that on Tuesday at 2:15, the Senate proceed to consecutive votes on the confirmation of the following nominations. Number 104, that's Pierce to be a member of the NLRB. Number 102, Johnson to be a member of the NLRB. And number 103, Ms. Zamora to be a member of the NLRB. Now, I might just say parenthetically, if those nominees were confirmed, coupled with the two nominees illegally appointed, whose illegal appointments continue to the end of the year, the NLRB would have a full complement of 5 members and able to conduct its business. I further ask consent that following those votes, the Senate proceed to the cloture motion filed on calendar number 99, that is Perez, to be Secretary of Labor. And further, if cloture is invoked, the Senate immediately proceed to a vote on the confirmation of the nomination. I would add parenthetically, that would eliminate the post 30 hours, assuming cloture were invoked, on the very controversial nominee, Perez, to be Secretary of Labor. Further, the Senate vote on the cloture motion filed on calendar number 98, McCarthy, to be EPA Director. And if cloture is invoked, the Senate proceed to vote on the confirmation.
The quorum call will be dispensed without objection.
Mr. President, I ask unanimous consent that Nate Converse, Max Ernst, and Trent Bloomberg of my staff be granted floor privileges for the duration of today's session.
Without objection, so ordered.
Mr. President, I also I have some comments and statements to make regarding filibuster reform and nominees. I ask consent that I be allowed to speak for up to 30 minutes.
Without objection, so ordered.
Mr. President, I want to take the floor to talk about these critical nominations that the Senate's currently considering. In all of the talk about these nominations, about the politics of recess appointments and everything, one thing that's been missing is a real consideration of who are these people. Let's bring it down to the personal. Who are these people? What have they done? What could they do to serve our country? We seem to have forgotten in all of this chaff that's out there and all the arguments going on as to what we're supposed to be doing to fulfill our constitutional responsibility to advise and consent to presidential nominations. As I understand it, we're supposed to look at the qualifications of the candidates, determine if they're fit to serve. Beyond that, that's it. Well, the answer with all of the nominees before us is an unqualified yes. They are qualified and they are fit to serve, and the President should be allowed to put together his team. That should be the end of our task. We should confirm them all today or tomorrow, I guess, when they come up, and move on to the many other important issues facing this body. I'm going to talk in a little bit just about the whole filibuster issue itself, but first I just want to talk a little bit about one of the first of the nominees that's up, and that's the President's choice to be our Secretary of Labor, Tom Perez. Without question, Tom Perez has the knowledge and experience needed to guide the Department of Labor, one of our key cabinet posts. Through his professional experiences, especially his work as Secretary of the Maryland Department of Labor, Licensing and Regulation. Yes, he was basically the Secretary of Labor for the state of Maryland. And he developed a very strong policy expertise about the many issues that confront American workers and businesses. He spearheaded major initiatives on potentially controversial issues, such as unemployment insurance reform, worker misclassification, while finding common ground between workers and employers to build sensible, common-sense solutions. It won him the support of business community and worker advocates alike. To quote from the endorsement letter of the Maryland Chamber of Commerce, Quote, Mr. Perez proved himself to be a pragmatic public official who was willing to bring differing voices together. The Maryland Chamber had the opportunity to work with Mr. Perez on an array of issues of importance to employers in Maryland, from unemployment and workforce development to the housing and foreclosure crisis. Despite differences of opinion, Mr. Perez was always willing to allow all parties to be heard, and we found him to be fair and collaborative. I believe that our experiences with him here in Maryland bode well for the nation, end quote. Maryland Chamber of Commerce. Mr. President, Tom Perez has dedicated his professional life to making sure that every American has fair opportunity to pursue the American dream. Most recently, as the Assistant Attorney General for Civil Rights at the Department of Justice, he has been a voice for the most vulnerable, and he has reinvigorated the enforcement of some of our most critical civil rights laws. He's helped more Americans achieve the dream of home ownership through his unprecedented efforts to prevent residential lending discrimination. He has stepped up the Department of Justice efforts to protect the employment rights of service members so that our men and women in uniform can return to their jobs and support their families after serving their country. As the Senate author of the Americans with Disabilities Act, I'm particularly pleased with Mr. Perez's long history of strong leadership on disability rights issues. While at the Department of Justice, he has helped ensure that people with disabilities have the choice to live in their own homes and communities rather than only in institutional settings, and to receive the supports and services to make this independent living possible. Like any leader whose career has involved passionate and visionary work for justice, Tom Perez's career has been one of making difficult decisions, management challenges. He's been the target of a lot of accusations and mudslinging and misperceptions. But we have looked, and I have looked carefully into his background and record of service. I can assure my colleagues that Tom Perez has the strongest possible record of professional integrity, and any allegations to the contrary are totally unfounded. Now again, Mr. Perez appeared before our committee, was willing to answer any and all questions. Those that were at the committee, those that were submitted letter, he's answered more than 200 written questions. He made himself available to any senator who wanted to meet with him. So he has been most accommodating. And I can say that they have provided all the access, the administration has provided all the access that people have wanted to his personal emails. In fact, this administration, I can say from my experience over the last 29 years, has gone further in providing access to even personal materials of Tom Perez than any president has ever done before, any administration has ever done before. So again, he's been thoroughly vetted. He has the character, integrity, and expertise to lead this cabinet and the Senate. And the Senate should vote on this. And when I say the Senate should vote on it, we should vote on it with a majority vote. But no. Mr. Perez has been filibustered and held up to a 60-vote threshold. Now we know that Mr. Perez has well over 50 votes, the majority, but because my friends on the Republican side are stonewalling this, he may not have 60 votes. But why should it take 60 votes, I ask? Why shouldn't it be a majority vote up or down? Now, the same is true for our nominees for the National Labor Relations Board. Again, these are three exceptionally well-qualified candidates. Mark Pierce has been a board member since 2010, chairman since 2011. He was previously a union-side attorney in private practice, before that a career attorney at the National Labor Relations Board. Richard Griffin is former general counsel of the Operating Engineers Union, and again a former career attorney at the NLRB. Sharon Block served as Deputy Assistant Secretary for Congressional Affairs at the U.S. Department of Labor, and before that was on our Help Committee. She was a senior counsel for Chairman Kennedy when Senator Kennedy was chairman of our committee. And again, she's a 10-year veteran of the NLRB. Again, I've yet to hear one senator question their qualifications. Question their qualifications. Indeed, even the ranking member on the Help Committee conceded at their hearing that these candidates are exceptionally well qualified and that he admired their qualifications and their distinguished backgrounds. Now, they've been thoroughly vetted. They've met with any senator who asked. They've answered more than 100 written questions each. They've become before our committee in a public hearing, not typical for all NLRB nominees, I might say. They produced every document requested, answer every question they've been asked. So again, if we concede that they're all exceptionally well qualified, thoroughly vetted, why can't we vote on them? Up or down? Majority vote. Again, some time ago, my friend Senator Graham, when speaking about the Senate's role in the nominations process, said, quote, "Our job, as I see it, is not to say what we would do if we were president. Our job, as the Constitution lays out for us, is to advise and consent by a majority vote, to make sure the president is not sending over their brother-in-law or sister-in-law or other unqualified people," end quote. So no one on these lists is anyone's brother-in-law or sister-in-law, I might add, and everyone is exceptionally well qualified. Again, if we're doing our constitutional duty, we would confirm all of these nominees today and nominees tomorrow and move on to our legislative work. So why aren't we doing that? Well, because my friends on the Republican side are hijacking these nominations and this nomination process to try to make changes to laws they know they could not change through regular order. So a single senator, a lot of times, or a handful of senators might hold up a nominee, not because the nominee is not qualified, but because they want some changes made someplace else that they don't feel they can get through the regular order of business in the Congress. Well, for example, my friends on the Republican side, they don't like the National Labor Relations Board. So what do? They can't repeal it, so they make it inoperable. Make it inoperable by not letting us confirm nominees. In fact, one of my Republican colleagues announced his intention to filibuster the NLRB nominees 6 days before their nominations were announced. 6 days before. In fact, he went on to say that an inoperable NLRB would be good for the country. Well, if that's the way they feel, offer amendments here to defund it, to do away with it, repeal the law, but then to hold up qualified nominees to carry out the law. The National Labor Relations Act is the law of the land. The National Labor Relations Board is constituted under that law to carry out its functions. And so to hold up qualified nominees because they want to change the law, again, is to try to get something done that they couldn't otherwise do through the regular order. Again, this level of obstructionism is unprecedented in the nomination process. Repealing laws by fiat is not and was never intended to be a part of the Senate's advise and consent function. A senator's dislike for a particular law or a particular agency certainly was not intended to prevent qualified and dedicated people from answering the President's call to serve their country. And again, it's the American people, not only the nominees, but the American people who suffer from these unprecedented abuses of the process. The laws that these boards and agencies and departments enforce are important laws designed to protect people. And when the system breaks down, or in this case, intentionally undermined, real people are hurt. Now, take the example of the National Labor Relations Board. They have to have a quorum of 3 members to act. If there are fewer than 3 at any time, the board cannot issue decisions and must essentially shut down. Now, the board currently has 3 members, but Chairman Pierce's term expires in August, next month. At that point, the Labor Board, National Labor Relations Board, would be unable to function unless we confirm additional members. Now, keeping the board open is vital to employees, employers, and our economy. Without the board, workers cannot seek justice if they are discharged or discriminated against for, say, talking with colleagues to improve their working conditions, or for joining or assisting a labor union, or for organizing a labor union. There are no laws out there that predict. The only avenue available to these employees to file a grievance and to have their grievance heard and adjudicated is to file a charge with the National Labor Relations Board. Without it, they have no options at all. So if the NLRB, the National Labor Relations Board, can't function, workers effectively don't have any rights. And yet, one of my Republican colleagues said an inoperable NLRB would be good for the country. Imagine that. Leaving workers without any forum, without any recourse to have their grievances heard. Again, the same, I could also say the same is true of the Consumer Financial Protection Board. Again, it was created, as we know, part of the Dodd-Frank Act, with a simple idea in mind. Consumers deserve to have a watchdog looking out for their best interests when using financial products and services, from mortgages to credit cards to student loans to payday loans. So with the creation of the Consumer Financial Protection Bureau, consumers now have that cop on the beat looking out for their well-being. Now, Mr. Cordray, who has been chosen by the President to head this agency, has carried out his mission admirably. But if Republicans have their way, he'll never be confirmed. Never. And not only will they lose his leadership, but the ability to adequately oversee these financial services and financial products and to protect American consumers. So by refusing to confirm Mr. Cordray, and if I'm not mistaken, I believe his nomination now entered its over 500 days, if I'm not mistaken now, 500 and some days that he's been held up. So by refusing to confirm him, they're using, again, the Republicans are using this nominations process to thwart the intent of the Dodd-Frank law. And that really brings us to the point, the crux of what is going on around here that has been in the press so much lately, that we're going to have an unprecedented caucus of the Democratic senators and Republican senators out here in the old Senate chambers at 6 p.m. tonight to air these grievances. As we know, the Majority Leader has laid down last Thursday a number of these nominees, filed cloture on them. We'll bring them up tomorrow. If the Republicans continue to filibuster, the Majority Leader has made it clear his intention to change the rules of the Senate using 51 votes to provide that nominations for executive branch positions are not subject to the filibuster rule. So that's what we're talking about here. We're talking about the nullification of laws already on the books through the abuse of the Senate's power to advise and consent to nominations. Nullification. Read your history books about nullification. It was one of the issues that we fought the Civil War over. Could states nullify on their own federal laws? Well, what we're seeing here are the Republicans saying we can nullify the essence of laws or what boards are supposed to do by abusing the advise and consent clause of the Constitution. It's appalling, and something has to change. Mr. President, I first took this floor on this issue in 1995. I think I have it here someplace. Yes, here's the congressional record. January the 4th, 1995. Now, it was an interesting time. The Democrats had lost control of the Senate. Republicans were now in charge. And I, along with Senator Lieberman and Senator Pell and Senator Robb from the great state of Virginia, proposed a change in the rules that wouldn't end the filibuster, but it would keep the filibuster as it was kind of intended, as a method whereby the minority could ensure that they could amend or offer amendments on legislation. See, the right of the minority should be to be able to offer amendments, not to have them adopted, but the right to offer them and debate them thoroughly and to have them voted on. And secondly, to make sure that the filibuster could be used to slow things down, but not to be used to stop something. That's what I proposed on January the 4th of 1995. I said at the time, I basically said, if we don't change it, I said it's getting worse. 1995. I said it's getting worse. But I said I believe in the long run it will harm the Senate and our nation if this pattern continues. And I went on to talk about the rising tide of the filibusters. I said, clearly this is a process that's out of control. 1995. We need to change the rules. We need to change the rules, however, without harming the long-standing Senate tradition of extended debate and deliberation and slowing things down. Then I went on to talk about, when I laid that amendment down, that proposed rule down, about just how dysfunctional this place was becoming. If you think it was bad in 1995, you should see what it's like now. It's just, never in my wildest dreams did I think in 1995 that 18 years later, the Senate would come to this point where we simply can't do anything unless we have 60 votes. Unless you have 60 votes. We now have a system whereby 41 senators decide what we do here. Essentially, that's what they do. 41. And through the use of the filibuster, a handful of senators can really thwart the will of the Senate. 18 years later. Well, Mr. President, there has been a lot said about different nominees and what's going on here. There's been this accusation and that accusation. You got to cut through all that fog and all that haze. I referred to it in 1995 as sort of like the fog of war. Sort of like the fog of war. You got to kind of cut through it. There's only really one question that we need to ask ourselves, and the American public needs to ask themselves. Should a nominee, should a person selected by a president, any president, Democrat, Republican, I don't care, any president, should a nominee, a person selected by that president to be a part of his or her team, after thoroughly vetting, after a thorough committee hearing, after making sure there's nothing terribly wrong with this person, they meet the qualifications and they've been thoroughly vetted, the question to be asked is, should that person have an up or down vote on the United States Senate with a majority vote? Or is it going to require 60 votes? 60 votes. Again, the Constitution of the United States very clearly points out there are only 5 times when the Senate needs a supermajority to act. You know, things like impeaching the president, expelling a member, adopting a treaty, joining a treaty, approving a treaty, things like that. And all other things, the Constitution envisions a simple majority vote. That's the real question here. There is no other real question before us. Now, Mr. President, before I yield the floor, I just want to address an issue that has come up regarding the National Labor Relations Board nominees. I want to set the record straight. I take the time to put this in the record. There have been accusations made here on the Senate floor. I shouldn't say accusations. There have been sort of stipulations, comments made that two of these board members are serving illegally, that they were illegally put on the board by President Obama. Now, that would be Sharon Block and Richard Griffin. Now, let's look at a little history here. They were appointed by the President in January of 2012 as a recess appointment because the Republicans would not let us vote on them. And since we needed a National Labor Relations Board to function, the President gave these two people a recess appointment in January of 2012. They have been serving since that time. A case was taken, the Noel Canning case, was taken to court. They were taken to court to decide whether or not the President had the authority to appoint them as recess appointees. The D.C. Circuit Court issued an opinion. And the reasoning they used was contrary to any other court reasoning in the past about recess appointments. The D.C. Circuit said that no, the President could not make those appointments, and furthermore, the President can only make a recess appointment during the intervening times from one Congress to another. No other court has ever held that. Now, there was another court that agreed that the President couldn't make these recess appointments, but they didn't go that far. They just said that what the President did was not a recess. What he did it was not in a recess. Other courts, 2nd, 9th, 11th Circuit courts, have all decided these things differently in the past. So what we have here is a decision by one court, the D.C. Circuit, taking a position that has never been taken before by any court. You have another court, the 3rd Circuit, that narrowly defined the President's power. Then you have all the other circuit courts that were basically all over the place on this in the past. So what happens? Now this case goes to the Supreme Court, and the Supreme Court will decide this during the 2013-2014 term. So, Sharon Block and Richard Griffin are on the NLRB. They took an oath of office to carry out their responsibilities. Now, some of my Republican friends have saying they should resign. They should get off the board because they're serving illegally. They're not serving illegally until the Supreme Court has made a final decision. I've said before, the contention of some of my friends on the Republican side is like this Alice in Wonderland, you know, first the verdict, then we have the trial. Well, I don't know what the Supreme Court will decide. Don't know. Now, we've had precedents in the past. There's a long-standing NLRB precedent when the agency faces a split in circuit court opinions. When the D.C. Circuit ruled in Laurel Bay versus NLRB that the NLRB needed 3 members to have a lawful quorum to act, again, this was contrary to the decision of other circuits, the 2-member board, consisting of Republican Peter Schomburg and Democrat Wilma Liebman, continued to issue decisions until the legal issue was finally resolved in the Supreme Court. Now, the Supreme Court said, no, they need more than 2. You've got to have at least 3 people to make decisions. Now, the 2-member board, during that interim time, issued decisions in hundreds of cases after the D.C. Circuit's adverse ruling, yet not one Republican senator called on either member to resign. And so what happened? After the Supreme Court issued its decision, and the court was now had more than 3 members, the board, had more than 3 members, They went back and looked at these decisions, and if there were still open contentions, they reviewed them and issued another decision. Now, some of the decisions were accepted by both sides, and people moved on. Those that weren't were redecided by the board, including the two people that had served on that board during that interim period of time. So again, we have a recent precedent, and this was just within the last 5 years, if I'm not mistaken. Yes, 5 years. So we have a recent precedent that demonstrates that both Block and Griffin are acting appropriately by remaining in place, and that the NLRB is acting appropriately by continuing to issue decisions pending the resolution of this issue by the Supreme Court. They cannot and they should not resign because they took an oath of office to fulfill their duties, and they must fulfill that oath. After President Obama made these appointments, each new board member took an oath of office promising to fulfill their duties as a member of the NLRB. So I just wanted to clear that up. They are not illegal. And we await the Supreme Court's decision on this. And I have no idea how they're going to decide because there's been a split in the circuits. But as I've shown, this issue has come up before where we had a case split in circuits. Two board members continued to issue decisions. No one here asked them to resign. And this was in the last 5 years. No one asked them to resign. But now, for some reason, my friends on the Republican side want to deny the president his choice of people to serve on the NLRB. Now, two of those people, Ms. Block and Mr. Griffin, let's say the Supreme Court says, that the president couldn't appoint people during that recess appointment. Well, okay. We're not talking about that now. We're talking about an appointment that's going to take place right now. And he should be allowed to have who he wants, as long as they're thoroughly vetted and they're qualified. And like I said, no one has questioned their qualifications. So the president should have the right to have his NLRB board put in place now. And the question of whether or not decisions that have been made in the last year and, 5 or 6 months, those decisions, just like the ones before, in the Laurel Bay case, in the Laurel Bay case, they went back and revisited those and issued their decisions. Same thing can happen here. So don't let anyone tell you that these nominees are illegal. That is absolutely not true. People may think it's true, but it's not true. So, Mr. President, I keep hearing that, well, now there's overtures from the Republican side to make some deals, to make a deal on not having the vote tomorrow on doing away with the filibuster rule on nominations. Oh, I've heard all kinds of things floating around, this deal here and that deal there, and we've got a little deal here. Since I took the floor in 1995 as a member of the minority, I might add, to propose a change in the filibuster rules, since that time, this issue has come up several times since 1995. Every time, there's always a deal. There's always some little deal made so we don't fix what's wrong with the Senate. We just sort of paper it over and move on. I hope that doesn't happen again. Every time a deal was made and it was papered over, things got worse. Every single time they got worse. Oh, they might have been okay for a little bit, and then we go right back into our old ways again, right back into our old ways. The old ways won't work any longer around here. They just won't. I hope that the only deal that is struck is that the Republicans agree that we all agree that any president should have his or her right to put their team in place by a majority vote of the advice and consent of the United States Senate. Thoroughly vetted, committee hearings, answering questions, yes, but an up or down vote with a majority vote in the United States Senate. That is the only deal that will get us out of this trap we find ourselves in. It's the only thing, I think, that will reassure the American people that once again the United States Senate is going to function. It's going to do its job. It's not going to be thwarted by a handful of people, or one or two or three or four people. And that we can actually move this country ahead and let this president, the next president who may be a Republican, yes, let that president have his team. I said that in 1995 as the minority. I've said it in the majority. I've said it in the minority, and I say it back again in the majority. So I hope tomorrow we finally put an end to this nonsense of the filibuster on nominations at a bare minimum. I would like to see the filibuster changed even more than that. But at a minimum, get rid of the filibuster on nominations to the executive branch. Mr. President, I yield the floor.